We're still not live?
We're live now.
Okay, good afternoon, ladies and gentlemen. This is Dr. Olu Asekun here. Welcome to our weekly podcast. Today is another beautiful Wednesday. Please invite your friends, family, colleagues at work and join us as we proceed with this podcast. Today's podcast will be very brief because I have to be in court in less than an hour. So I have to be in court. So I'm going to be very brief. So while I'm going through the update, if you have questions, please send in your question. Bless you.
Thank you.
Please send in your question if you have questions while we are going through the update. But of course, it's going to be brief because I have to be in court in less than 1 hour. So today, as usual, we talk briefly about the updates and then we go into questions and answers. Hopefully, I have about 40 minutes or so to answer questions. But talking about the updates, not much happened between last week and now. However, Trump administration is never devoid of any news. So, the first thing I want to talk about is the change in the CSPA age calculation. CSPA means Child Status Protection Act. Child Status Protection Act. And I believe that we have a podcast on Child Status Protection Act before. So anyone who wants additional information on that can check our podcast on Child Status Protection Act. But that age calculation is what changed effective August 15th. What's today's date? Today's 13th? Yeah, so it's going to be effective on Friday. So by Friday, August 15th, the new CSPA, Child Status Protection Act calculation will be using final action date as opposed to visa availability. For those who understand how to check visa bulletin, you will understand the difference. For visa application, the dates are always earlier than the date for final action. This thing is echoing.
That's what I keep saying. It's driving
Yeah.
me nuts. I think
Maybe you reduce the volume on the.
I don't know why. I think it has something to do with that.
Okay. For those who understand how to check the visa bulletin, you will see that the date for visa application is always earlier than the date for final action. And as I've stated multiple times on our podcast, for visa applications, those are the people applying for immigrant visas from outside the United States. For final actions, those are the people applying for adjustment of status inside the United States. So that is the difference. So the Department of State believe that those who are applying from outside, because it will take longer time. I can't hear myself. Okay, yeah, I can hear myself now. I can hear myself now.
Okay.
Is there a way to verify if the listeners are hearing me?
It's okay. No echo in the saying, and they can hear you.
Okay, so now, those who are applying from outside, they are the one that uses the visa application. Those who are applying for adjustment of status.
It has a volume.
Oh, on the TV.
On the TV, it has volume. Okay,
Oh,
now
okay.
say
Hello. Oh, yeah.
Oh, okay.
Okay.
Yeah, I think that was a problem.
Okay, yeah.
Okay, because that has been driving me up a wall.
Okay. Well, sorry about that. So as I was saying, those who are applying for immigrant visa through the embassy outside the United States, they are the one that uses the visa application date in a visa bulletin. Those who are applying for adjustment of status inside the United States, they are the one that uses the final action on the visa bulletin. So, for the purpose of calculating the Child Status Protection Act, one of the requirements is that in order for the child's age to be frozen, visa must be available in the category in which the application is made. Now, talking about visa availability, because those who are applying from outside, because their own date is always earlier than those who are inside, so they always have an advantage when it comes to Child Status Protection Act versus those who are applying from inside. Sometimes the difference between those dates could be up to 6 months, sometimes up to 1 year between visa application date and final action date. So now that advantage is what the Trump administration is trying to remove, because now they want everybody, whether you are applying from inside the United States or you are applying from outside the United States, they want everybody to use the final action date. So what that simply means is that more people will be disqualified from benefiting from Child Status Protection Act, especially those who are applying from outside, because the benefit that they used to have, the Department of State want to take that benefit away. In fact, they are going to take it away effective August 15, which is in 2 days. So if you have a child that is eligible for Child Status Protection Act, CSPA, you want to quickly contact your attorney so that they need to notify the NVC or the embassy, depending on where your case is, that you intend to utilize the CSPA as it stands today, not until the new policy comes into effect on Friday in 2 days. So that is the first update. The second update I'll be talking about is that the Department of State also announced a new policy that they will no longer issue no objection for J1 visa waiver. For waiver, normally when somebody comes to the United States on a J1 visa, J1 status require a 2-year foreign residency requirement. So anybody who entered the United States on a J visa, they are supposed to return to their home country at the end of their period of authorization for a maximum of 2 years. They cannot adjust in the United States and they cannot change status in the United States until after they have returned to their home country for 2 years. However, an applicant may apply for a waiver where the home country does not object to that waiver. But whenever an applicant applies for a waiver, the Department of State is also required to write a recommendation on the waiver, whether they object to it or not. So most of the time, the Department of State will issue no objection letter. But under this new policy, the Department of State has now indicated that they will no longer issue no objection letter. So what is not clear with this policy so far, something that is not clear to me, is what happens to those who already have the no objection letter, but the waiver has not been approved. So it is not clear whether this is going to be whether this is going to have a retroactive effect or if it is going to be only new letters. But so far, the announcement is that they will no longer issue no objection letters. So they will no longer issue favorable recommendations for J1 no objection letter. So that is what the Department of State have announced. So the next thing that I want to talk about before we go into question is there is a new case law by the Board of Immigration Appeals. So the Board of Immigration Appeal, they rule, the case law is called Matter of Akhmedov. Akhmedov, I think is a Russian name. They ruled that no bond should be granted where a respondent failed to timely notify the immigration court of change of address. I'm bringing this up in this podcast because this is something that I know that a lot of people will be victims. A lot of people. From time to time, people get into removal proceedings. They don't provide change of address to the court. A lot of time, people have pending application with USCIS. They don't provide a change of address to immigration. I want to state categorically that it is a requirement of the law. It is a mandatory requirement that if you are in removal proceedings and your address change, you must notify the court within 5 days of the change of address. You must notify the court. So if you fail to notify the court, the Board of Immigration Appeal, BIA, they have now issued a case law, a decision that is binding, a decision that has been designated as precedent. And that decision says if you fail to provide a change of address, if immigration arrests you, if you are arrested by ICE, you will not get a bond. It's a new decision by the Board of Immigration Appeals. My people, we all know what is going on under this current administration. They are looking for every opportunity. They are looking for excuses. They are looking for little things that they can use as justification. Here is one of them. Please do not fall victim. If you move, immediately notify your attorney and ensure that your attorney file a change of address, especially if you are in removal proceedings. It is not enough to just call the attorney's office and give them your new address. Please follow up, because if they lock you up, you are the one that will be in detention, not your attorney. So follow up. Make sure that a proper change of address is filed in court, because this is a very, very dangerous decision, but it is what it is. I don't have the power to change it. And because this decision has been designated as a precedent, immigration judges will not have a choice. Even if they wanted to grant you bond, they will not be able to, because now the Board of Immigration Appeal, which is superior to immigration court, they have ruled that where a respondent or an alien or a foreigner who is in removal proceedings, where they fail to notify the court of a change of address within 5 days of moving, if they are picked up by immigration or by ICE, they are not entitled, they are not eligible for bond. It's going to be a mandatory detention, because according to the BIA, not providing an address will be evidence that you are a flight risk. That is what the BIA decided. So if you don't take anything away from this podcast today, even if you are not the one that is directly in removal proceedings, or even if you don't have a case pending, please, you may know someone who does, because I tell you, a lot of people are going to be in detention. And this is not the best time to be detained by immigration, because right now they are sending people all across the country. They can arrest somebody in Dallas and detain that person in Ohio. They can arrest somebody in Houston and detain that person in California. They are sending people to different areas right now. It doesn't matter your address. They are not considering address. They are just sending people to different places. You don't want to be detained in California. What is that thing? Alligator thing. What is it? What is it called?
Alcatraz, that's
Aha. You don't want to be detained in that alligator Alcatraz in Florida. Please take this thing very seriously. This information is very important. The last thing I will talk about before I go into question and answer on regarding the update. Now, this is about visa lottery, DV, diversity visa lottery, for countries that still participate in the diversity visa lottery. There is going to be a lot of changes coming up. Right now, the changes are not effective. They have only provided a notice to the public, and they are going to be accepting public comment until September 19. What happened was that when Donald Trump was the president between 2016 and 2020, he actually attempted to make these changes, but the court stopped him that he didn't follow the procedure. They didn't give the public the notice and allow people to comment before they enacted that rule. So that was why the court stopped it. So because of that, they are bringing that rule back right now, the proposal, but at this stage, they have allowed people to comment on it. So that comment period will be ongoing until September 19. So we still have about a month and a few days. So, however, these are some of the proposed changes that they want to introduce to the DV lottery. The first one, currently, if somebody is going to play the DV lottery, the application form will be asking for age, how old. But now they are saying that they will replace that age with date of birth. They will no longer ask for age, but they will ask for date of birth. According to the public information, they are doing this to prevent fraud. They claim that they identify so many fraud where some people will play lottery on behalf of so many other people, even without their knowledge. So when any of the names are selected, they now approach that person and tell him, oh, I play lottery on your behalf and you won. Now give me X amount of money before I can give you the information. Well, that is what the government is saying. I don't have any evidence of that, but that is one of the justification they are providing for all these changes. So they are going to replace age. They will no longer ask for age. Instead of asking for age, they will ask specifically for date of birth. The next thing they want to replace is gender. Gender. They will no longer ask for gender. Instead, they will ask, what is your sex? So they will replace gender with sex. So apparently they want to eliminate LGBTQ. That is what that one means. Then the third thing that they want to change, they want to insert the word shall. Shall. Well, for those who are students of English, you will know that there's a difference between shall and will. I will do it. That's not with certainty. I shall do it. That means it is mandatory. So they want to make all those changes mandatory. So what that means is that if you miss any of the requirement, it will be a ground to deny your DV lottery application. So they just want to make sure that not many people are selected under the DV lottery, because they will have so many excuses now to deny people the DV lottery. Now, the last thing that they want to change on the DV lottery application is that now they want to make a biometric page of international passport. They want to make it a mandatory requirement. So whenever you play the lottery, you will have to upload your unexpired and valid passport. The biometric page and the signature page of your passport must be uploaded into the system when you are playing. Again, they claim that this is to eliminate fraud. So those changes are going to be coming up on the DV visa lottery, but it is still for public comment right now. The public comment period will be lasting until September 19 of this year. So after that, once they review the public comment, if there are going to be changes, they will let us know. If there are not going to be changes, then they will publish the amendment, and it becomes final. So those are the changes, those are the updates that we want to talk about today. Now let's quickly go into question. As I said today, I have a case at 1 o'clock, so I probably will be having about maybe 35 minutes for questions. So let's quickly start. Question 1, please. Okay. Hello, sir. Please, can you help shed more light on the USCIS update policy on CSPA age calculation that was released 8/8/2025? I filed an I-485 category EB4 R2 for my dependent. Is it inactive? Yeah, was this posted before I explained the... So I believe my explanation will have answered the question. I don't want to repeat it. I mean, the main difference on the CSPA, Child Status Protection Act, is whether the beneficiary, your child, if your dependent is outside the US or inside the US before now. So what it means that for visa bulletin, when you look at visa bulletin, there's a difference between the date in each of the categories, either EB1, EB2, EB3, EB4, EB5, or even family-based, FB1, 2, 3, 4. There are differences in the date between visa application and final action. Visa applications are those who are applying for immigrant visa outside of the United States. Final action are those who are applying for adjustment of status inside the United States. So before now, the CSPA, when they are looking at the visa availability, because what does CSPA mean? It means Child Status Protection Act. So it prevents a child from aging out if an immigrant visa is pending on behalf of that child. In order for Child Status Protection Act to be available, that child must have filed the application. The application must have been pending before the child turns 21. And visa must be current before the child turns 21. Now, if you look at the visa application category under the visa bulletin, you will see that visa applications always have earlier dates than final action. Most of the time, the difference between visa application date and the final action date, sometimes it could be up to 1 year. The differences. In other words, sometimes when they are already processing maybe June 2023 for visa application, they may still be in maybe August 2022 for final action. So that is the advantage. So those who are applying from outside the country, they usually have an advantage because they will be able to show that as at the time the child turns 21, visa was already current because it is earlier. So in order for me to explain this thing better, because this is very important and I want to take my time to explain it so that every of my listeners will understand it, because this affects everybody, whether it is family-based or employment-based. Now, I'm going to use two different examples. Let's say we have a 20-year-old child whose father is a U.S. citizen, or whose father is a permanent resident or has applied for permanent resident, and that child is a dependent, but the applicant and the child, they are outside the United States. Okay, to give content to my, can you help me pull the current visa bulletin? I want to use real example, current visa bulletin, and help me look at any category that the visa application and the final action is different.
Okay.
So let's say two couples, like I said, we have two couples. One is outside the United States applying for green card with a 20-year-old dependent. The second couple is inside the United States applying for a green card with a 20-year-old dependent. Help me look at maybe EB3.
Okay.
Any of them, yeah, EB3. So give me the date for visa application and the date for final action. So two examples. One family is applying for green card from outside the US with a 20-year-old dependent. The other family is also applying for green card inside the US with a 20-year-old dependent. Now, oh yeah, okay. So now, while waiting for the exact date, let's say the application was filed when the dependent was 18-year-old. Visa is still not current. Now, the child is going to turn 21 on August 30th of this month. That is the one outside the United States. Let's say that child is going to turn 21 on August 30, 2025. The one applying for adjustment of status inside the United States, they also have a dependent child. Their own application has also been pending since 20, what did I say first time? 18 or? 20. Okay. Their own application has also been pending at the same time. Now, their own dependent child too is going to age out. They are going to age out. Or since this person is talking about R1, let me look at EB4.
It's still loading.
What's going on?
I don't know. I'm trying both phones.
Maybe because of the number of people online.
I'm not on Wi-Fi
Oh, okay.
on either phone.
So the 20-year-old from outside the US, the 20-year-old from inside the US, both applications have been pending, let's say since 2020. Now, the one in the US is going to age out August 30. The one outside the US is going to age out August 30. Now, under the current Child Status Protection Act, if visa availability for the one that is applying from outside under the visa application category, if that visa is already current, but the one in the US, the one that is applying from the US, because that one will be applying under the final action category. So the one outside the US may be able to claim Child Status Protection Act and get the green card despite aging out in the application, despite turning 21. The same child in the US will not qualify for Child Status Protection Act because under the final action, visa is still not current, even though it is the same category. But because under visa application, the one outside, they always give them visa availability. Their own visa is always current earlier than the final action. So that advantage that those who are outside the US, the advantage that they have, that is what this new policy is taking out. I believe that should be clear enough. Please scroll to the next question.
second part of that question.
Oh, can you go back then? Let me read it in context. Okay. I filed an I-485 category before for my dependent in active status, 17 and 16 respectively, which was accepted. Priority date 10 February 23 and receipt date 14th June 2024. With this new policy, is there anything to worry about? Well, this person didn't indicate whether the children are here. Can you go back to the first part of the question? Are they here? Well, if they were in R2, I assume that they are here. So if they are here, this new policy does not affect him because if they were here, they would have been subjected to the final action category. And the final action category is what the Department of State is attempting to make across the board now. So next question, please. God bless you, sir. Amen. Okay, good day, sir. May God bless you and your team. Amen. I and my siblings filed under my dad. He passed away 3 weeks ago. Oh, sorry about that. Please accept my condolence. What is our fate now? I have been here for 8 years. Others are in other countries. Unfortunately, I will need more information because I need to know what the dad filed. Was this based on marriage? I will need more information. So if this person can send in more clarification, even after we close the thing, if the person can provide more.
It will have to be while you're online. Otherwise, the message is not.
Okay. Yeah, if the person can provide more information or even provide phone number, I don't mind calling the person once I'm done in court later today. But I will wish to answer the question, but unfortunately, I can't answer it without the fact. I will need to know the type of application that the father had pending so that I'll be able to determine whether it is something that can be salvaged. Of course, if it is a family-based petition, it may be salvaged. But there are a lot of things I will need to know before I can tell you whether you will still be able to do something or not. So if you are online, please send more clarification or provide your phone number so that as soon as I finish in court later today, I'll give you a call and explain what your options are. Next question, please. Okay. Hello, sir. Thanks for all you do. Sir, it's almost a month I did my biometrics and even went for my marriage-based interview, almost 3 weeks, but my work authorization is not out. What can I do to hasten it? Well, every case is different. I don't know how long it's been pending because work authorization also has processing time, which is completely different from green card application or adjustment of status. One thing I will tell you, even though they have not officially announced it as a policy, but looking at antecedent, if you recall, well, I'm not sure if you were here during Donald Trump's first term. If you recall, during Donald Trump's first term, when application for green card or any application that requires employment authorization, whenever they are filed, at that time, there was a policy, excuse me. At that time, there was a policy that the main application should be expedited so that if the application is denied, the application for employment authorization will also be denied. They had that policy between 2016 and 2020 when Donald Trump was the president. However, when Biden came, Biden reversed the policy. This time around, Donald Trump administration has not announced that policy again, but I've seen a pattern. I don't know whether it is positive or negative yet. I've seen a pattern every new application for green card that is filed lately, they are expediting the process of the interview. And what that means is that if they decide to adjudicate and if for any reason they deny it, you are probably not going to get the employment authorization. So they have not announced it as a policy, but I've seen that pattern that cases are being expedited right now. You are not alone in this situation. I have a lot of clients who filed marriage-based adjustment of status within the last 1 month or 2 months, and they have already been interviewed. Some of them have been scheduled for interview. Some of them have attended interview. Majority of them have not received employment authorization. So again, I'm not saying this, they are going back to that policy, but I'm just telling you the trend that I've observed. So this is something that we have observed. So if they want to implement that policy, there's really not much you can do. But in the interim, go and check the processing time for employment authorization. If processing time has already passed, then you can do a service request. But if it is one of those 1 or 2 month application, there's really nothing you can do other than to wait.
One of our cases, they went for their interview about 2 weeks ago, and their EAD was approved today.
Okay.
So that's the same situation.
Okay.
Well, except for the
Yeah, I've also been told that we have other clients who attended interview about 2 weeks ago and they just approved their employment authorization today. So, like I said, if it is still within processing time, there is not a whole lot of things you can do other than to wait. Next question, please. Please watch the time so that I don't miss the court case. Hello, doctor. Thank you for all that you have been doing. Thank you, too. Is it true that an asylum claim referred to immigration court will not lead to a green card or naturalization? That is not true. That is emphatically false. If your asylum is referred to an immigration court, you have the opportunity to represent your asylum before an immigration court. You also have the opportunity to present a completely new relief before the immigration judge. So if your relief is granted and you are granted green card, you can still get, if you are granted asylum, 1 year after, you can still apply for green card and you can also still get your naturalization. I want to suspect, although I don't like I don't like the idea of guessing, but this person probably got the information wrongly from an online. There is a case that I think is the 10th or 11th circuit that just issued a case denying adjustment of status for someone who applied for green card while in removal proceedings. In that case, the court stated that because the asylum which was previously granted had been revoked, that is why they believe that the person is not eligible for green card, not because he was in removal proceedings, but because that asylum had been revoked. So if that is what is causing the confusion, but the simple answer to your question is no. Next question, please.
before we're saying that we were okay with it.
Okay, initially, that was before we fixed the, but at least we figured it out and we fixed that problem. Okay, sir, for IA64, if an unmarried sponsor without children will be sponsoring 2 people at different times within 6 months or a year, are they going to consider income for family of 2 or 3? Well, if an unmarried person without children will be sponsoring 2 people, they will consider the family of 3. They are going to consider family of 3. It doesn't even matter whether it's within 1 year or 2. For as long as any of the people that is sponsor have not become a citizen, that sponsorship must still be counted. So they are going to be counting family of 3. Next question, please. Hello, sir. Thanks, sir. Oh, thanks. Sir, what step to take after N400 interview? No decision was made until 120. I believe that should be days. Senator contacted and USCIS requested 90 more days to make decision. 90 days have passed, still no decision. That's it. Okay. Well, as I always tell people, he who lives in a glass house does not throw stone. If you know that you are not in a glass house, go ahead and file mandamus because that is a violation of law. The law specifically made it clear. Adjudication must be done within 120 days. It is statutory. So file mandamus. Although if you file mandamus, they will still have up to 60 days to respond. But that's your option to file mandamus. But don't try mandamus if you have skeleton. Don't try it if your house is not in order. Because under this administration, if you file mandamus and you have something in your skeleton, that thing will come out. I can assure you of that.
You have dirty laundry.
Yeah, so if you have dirty laundry, don't attempt mandamus. Next question, please. Good afternoon, sir. God bless you and your team for giving back. Thank you. Amen. I want to ask how guaranteed USCIS can reschedule marriage-based interviews scheduled for September 5th because my attorney told me she also has another interview scheduled for the same date as mine. Well, if the attorney presented evidence that he has a conflicting interview date, yes, the interview can be rescheduled. It can be rescheduled. It is guaranteed it will be rescheduled. However, I need to point something out. If your attorney is going to be requesting rescheduling by letter, you should attach evidence of the other interview because you have to provide a good cause for the interview to be rescheduled. There must be a good cause. Attorney interview conflict is a good cause, but it is not enough to say, oh, I have another interview. That is not enough. Your attorney has to present evidence of that other interview. So usually, I will attach a copy of the conflicting information. I will attach it to my request for the reschedule. But if a proper good cause request is made, yes, it is guaranteed they will reschedule it. Next question, please. God bless you, sir. Amen. Please, I'm on F2 for the past 8 years. My wife got agencies that file I-140 after her nursing board exam. She is back to school just to be on status while waiting for adjustment of status to be approved. Question 1. What is my fate as an F2 holder with ICE? You are okay. There is nothing to fear. There is nothing to fear. For as long as your wife is maintaining status, you are also in status. So there's nothing to fear. F2 is a valid status. It doesn't, just don't have criminal record. That's the only time you have to be fearful.
Do not join any protests.
They are telling me here that you should also not join any
Protest.
Protest.
Oh, yes. Yes. Please do not join any protest. If they are protesting against the government, don't participate. If they are protesting about the economy, don't join them.
Oh, and also social media.
And also avoid negative or be careful with what you post on social media. That's it. But generally, F2 is a valid legal status. There's nothing to worry about. The second question, It's 14 months we filed for adjustment of status. Any hope of it being approved this year? Well, that depends on the visa bulletin. Were you able to open the visa bulletin?
It never pulled up.
Well, you can pull it up on your own. If you are applying for adjustment based on nursing, that will be EB3. So check the visa bulletin final action for EB3. Yes.
I don't think it's considered to be on F2 anymore since they have a green card application pending.
I think he is a little confusing. Maybe he didn't understand it, but the way I understood the question, what they have pending is I-140.
Oh, now I got it up.
Okay.
What they have pending, if you look at the part 1 of the question, they have an employer who filed I-140. And he mentioned, you see, my wife got agencies that file I-140 after her nursing board exam. She's back in school just to be in status while waiting for adjustment of status.
Or to be filed.
Well, I don't know. Let me say this. It's a good thing that you pointed it out because some people misapplied these immigration terms. If what is pending is I-140, yes, it is good to be back on F1 and F2. Your wife back on F1, you back on F2 in order to be maintaining legal status. On the other hand, if your wife has already filed I-485, adjustment of status, then F2 cannot even be approved because your status is the I-485. So you cannot go back to F2 if you have a pending I-485. It will not even be approved. So if you are still online, you can quickly clarify it. If not, you should get the answer from this explanation. If what is pending is I-140, that is not green card. That is an immigrant petition upon which you are going to apply for green card when visa is current and when the I-140 is approved. Or even if the I-140 is still pending, for as long as visa is current, then that's when you apply for I-485, which is adjustment of status. On the other hand, if what you have pending is the I-485, then you don't even need F2. You are not even on F2 in the first place because the moment you submit I-485 adjustment of status, it is an immigrant application that terminates any non-immigrant status. So you can't have a pending I-485 and then have F2 at the same time. The I-485 will supersede the F2. Next question, please. I think you skip one in between part 1 and 2. Okay.
There was a part three for this one.
Oh, okay.
This is the last question he asked.
Okay, part 3. Can we travel out of the country? God bless you and your team. Amen. Well, again, that depends on what you have pending. If what you have pending is the I-485, you can apply for advanced parole in order to travel. On the other hand, if what you have pending is the I-140 and you still have your F1 and F2 visa, not I-94 this time, visa, then you can travel. If you don't have a valid F1 and F2 visa, if all you have is the I-94 that says DS, yes, you will be in legal status. But if you travel, you will need to go to the U.S. Embassy in the country that you travel to apply for F1 and F2 visa. So under this current administration, except it is extremely important, I will not advise you to travel if what you have is I-140. On the other hand, if what you have is I-485, yes, you can travel. The only thing you need to do is to apply for advanced parole, file Form I-131, and then once approved, you'll be able to travel. Next question, please.
9 minutes until 1.
Yeah, let me spend 4 more minutes.
Okay.
So I don't know how many questions I can answer in 4.
This person is the one that asked about the affiliate support earlier.
Okay, what's the question? Hello, sir. What if sponsor for IAC4 is not currently employed, but current IRS transcript meet the income requirement. Can unemployment person be a joint sponsor? No, unemployment person cannot, because one of the requirements for sponsorship is to provide recent pay slips. Immigration is aware that somebody may have a job last year and not have a job now. So that is why they ask for recent pay slip. You still have to submit the evidence of your income for last year, but you also need recent pay slip. So someone on unemployment cannot do that. I mean, there's a Yoruba saying that somebody who is being fed cannot feed other people. So if you are receiving unemployment, you can't be sponsoring people.
You can share.
Well, next question, please. Good day, sir. God bless you richly for all you do. Amen. You are really appreciated. Thank you. Sir, is it true that marriages to U.S. citizens to file for LPR is no longer granted? No, that is not true. That is not true. However, every immigration application, every immigration benefit is being highly scrutinized just based on President Donald Trump's executive action, executive order. The president signed an executive order instructing USCIS and EOIR to scrutinize every application in great detail. So it is not only marriage-based. Every application is being greatly scrutinized. But are they still approving it? Yes. In fact, as of today, I've received approval based on family-based petition. Yesterday, we received approval in this office based on, we receive approval every day. So those things are not true. But every application is being scrutinized. That is what changed. The next question. Hello, sir. Thank you for all you do. I just got my green card through marriage. I used to be on asylum before that. I want to know if I could travel to my country without issue coming back. This is very tricky. First and foremost, what is the basis of your asylum application? Because again, we are under an administration that is looking at everything in great details. They look at the past, they look at the present, they look at everything you have done, everything you have told them before, they check everything. So you have to go back to look at the application for asylum. Is it a frivolous application? You can make that determination for yourself, because frivolity simply means fabrication, something that never happened, something that was fabricated. Because if you painted a picture that, oh, going back to your home country is going to create a problem, you are going to be killed, you are going to do this, do that, and then you got green card through marriage, the next thing you do is to go back to that same place you claim you will be killed, that may be evidence of frivolity. So you have to look at the totality of the case. However, there are steps that I cannot discuss on online like this. So maybe you want to go back and talk to your lawyer that what can you do if you need to travel.
Okay, it's time.
12:55.
Yeah.
Oh, well, in as much as I wish to continue, I have to go now because I have to be in court in about 5 minutes. I have another case that I have to do. Even though it's electronic, it's online, but I still have to log in, set myself, get ready before the judge comes into courtroom. I hope to continue again next week. Until then, remember, stay safe, be careful, and remember to also share this podcast with your family, friends, and colleagues. Until next week, I remain yours truly, Dr. Olu Asekun, and my team. God bless.